reaching verdicts, they're more likely to find for against the defendant than they are. Well, now, let me rephrase that. When you have both a jury and a juror, individual judge, looking at the same case and trying to reach a decision, they usually agree, but when they don't agree, it's the case that the individual judge is more likely to find for guilty than the jury is. That is, the individual is more harsh than the jury is. Now, when Calvin and Zeisel first found evidence for that back in the 1960s, they thought it was because judges have lots of experience in courts and they tend to be skeptical about claims made by defendants. But in fact, this research on the leniency bias suggests that this might be simply due to the fact that you have a group making the decision, and the group is using the reasonable doubt standard, and under that standard you're supposed to give the benefit of the doubt. And individuals are not as likely to show that pattern as groups are, where there might not be a chance for some even division between one faction and another faction. When you're an individual juror, you don't have anybody opposing you, and so you don't have anybody making that argument that we have to give the benefit of the doubt to the defendant. Now, I'm going to briefly conclude by a discussion about the effective jury size and decision rule. Just by way of background, as you all know, juries traditionally are 12-person juries, not 6-person juries as I've been talking about. But you might not have ever asked yourself why that's true. And it turns out that it goes back quite a way, several centuries, to England, where for religious reasons people chose a 12-person jury. There were lots of references in Christian theology to the number 12 disciples and 12 tribes of Israel and so forth. And so when they had to decide on how large a group you would use to make these important decisions about guilt or innocence, they decided that 12 was a reasonable number. And it's also the case that traditionally jurors had to reach their decision unanimously. That is, you couldn't have any disagreement at all. If you had one person that held out against a certain verdict, then no verdict could be reached at all. Now, in the 1970s, the United States Supreme Court had considered whether the Constitution of the United States required that juries be as large as 12 and whether they had to agree unanimously. And they decided in these two cases, Williams versus Florida for jury size and in Johnson versus Louisiana for decision rule, that the Constitution did not require 12-person juries. You could use smaller juries, and that those juries could reach their verdicts non-unanimously. And their basic reasoning of the majority in the Supreme Court was that it really wouldn't make much of a difference, that smaller juries would reach pretty much the same verdicts as larger juries, and juries that reached decisions with, say, a large majority rule, that is, if you could get half or more of the juries to agree one way, then they would reach the same decision ultimately as those that were told that you had to reach a final unanimous decision, and therefore it shouldn't make much difference, and therefore states should be able to do what they'd like. Now, not everybody in the Supreme Court agreed with that opinion. On the issue of decision rule, whether you had to reach a unanimous decision, the minority in the Supreme Court said that doesn't the fact that you have some people in the jury that don't think that the person is guilty mean that there really is some reasonable doubt about that person's guilt? And the majority of the court said no, you can have an individual reasonable doubt, but not everybody agrees with that, and it's the fact that one person has a reasonable doubt doesn't mean that there is a reasonable doubt. They also said that one thing that worried them about not having unanimous juries is that if you don't have a unanimous jury, then couldn't you simply outvote people and not listen to their arguments? So in the 12 Angry Men film, people could have seen that in fact they had a majority. They didn't need to listen to Henry Fonda, and even if he had wonderful arguments for why the defendant was not guilty, they wouldn't have to listen. They simply could outvote him and reach a verdict and, in a sense, squelch any dissent from the majority opinion. On the issue of jury size, the dissenters on the Supreme Court said, are smaller juries as representative of the general community as larger juries? And the majority of the court said, well, it really wouldn't make much difference. But in fact, it's very easy to show that in fact the majority of the Supreme Court was wrong. So it's just a matter of sampling that smaller juries are less likely to be representative in the sense of including all the different types of people that live in a community. So for example, suppose we lived in a community where there were 5% of all the people living there were members of some minority group, maybe a racial or an ethnic or whatever kind of minority group. If you randomly compose 6-person juries out of that population, the probability that you would have in every 6-person jury at least one member of those minority groups is only 26%. But that goes up to 46% if instead of using 6-person juries, you use 12-person juries. So larger juries are more likely to reflect the diversity that exists in the community. So it would have been easy to show the Supreme Court that in fact as juries get larger, they become more representative. Now, the Supreme Court raised lots of questions about jury size that are psychological questions. In a sense, they said that how large the jury is doesn't affect the kind of decision they make. And there have been several studies now done looking at whether the size of a jury affects various aspects of the jury process. One thing that's been shown is that when you have smaller juries, you find that there's more even or equal participation among the jurors. So in fact, there seems to be some kind of better division of labor in the jury when you have smaller juries. And that's a vote in favor of the use of smaller juries rather